Hello, my name is Savannah, and I've chosen to do the Delaware County Intermediate Union petitioner versus Jonathan S., by and through his parents, also known as Mr. and Mrs. Walters. This case was held at the Commonwealth Court of Pennsylvania, and this was also argued on June 12, 2002, and was filed on October 29, 2002. For a quick understanding of the case, I will start that there was a rejected financial responsibility of education under the IDA Part C early intervention for a child with cerebral palsy, where the hearing officer relied on conventional education and the record was devoid of specific facts. Delaware County Intermediate was a party in which believed that they did not need to be responsible for fully funding this child's education due to having cerebral palsy, and Party 2 was Jonathan S.'s parents and the child himself, which felt that they should be fully funded for this preschool program. I will now state some important facts pulled from my source, which I've included below, and I'll be stating them from a reporter's point of view, as if I was reporting this to the paper or newscasting, making myself a third party to this court date. Delaware County Intermediate Unit, DCIU, appeals from a court order of the Special Education Appeals Panel, which affirmed an offer of a hearing officer. The hearing officer found that DCIU was financially responsible for the preschooler's placement of early intervention eligible student afflicted with cerebral palsy. The student is a preschool-age child diagnosed with cerebral palsy and was also found to have some orthopedical disabilities. Prior to the age of 3, the student had received early intervention services under the Part C of the Individuals with Disability Education Act, which is also known as the IDA. In January 2001, as the student approaches the age of 3, the department referred him to the DCIU for a multidisciplinary evaluation, which is known as an MDE, to determine students' eligibility for special education services funded by the Pennsylvania Department of Education and to assist in his planning for his problematic needs. DCIU recommended eligibility for early intervention services and supplemental intervention. The CER team reported that students need specific physical skills in the classroom-related tasks to function successfully in a variety of settings, including not only his home, his school, and his community. At a subsequent Individual Education Program IEP meeting on January 17, 2001, the IEP determined the student was exceptional and in need of specially designed instructions. As a result of its evaluations, DCIU offered student a program including 2 hours of weekly physical therapy, 1 hour a week of occupational therapy, and 1 hour of weekly educational services. Additionally, DCIU had offered the student a personal care assistant when enrolled in the preschool if he was to be enrolled, with further offered help in selecting and funding a preschool. Student therefore requested that DCIU fully fund his placement in an appropriate preschool program, which requested DCIU had denied. DCIU declined students' request to be placed in a preschool program with typically developing peers where he could receive intervention in the regular classroom on the grounds that it does not fund such programs for children with special needs. DCIU does not offer these programs directly and will only fund those programs if 1, the child needs includes severe cognitive, communication, or social delays, 2, the child would otherwise be eligible for specialized classrooms, and 3, the child's IEP includes goals, objectives, and that specifically design instructions in the area of cognition, communication, and social skills. So with these standing facts, it was found that the student subsequently requested a hearing on the issue of the DCIU legal responsibility to fully and completely fund the student's preschool program. The parties agreed that the facts of this case were undisputed. After oral argument of the counsel, the hearing officer, by order date August 29, 2001, ordered DCIU to provide a student with a free appropriate public education, which is also known as the FAP, as opposed to solely providing appropriate early intervention services as DCIU had offered. In short, for a student to be eligible under the IDA's definition of disability and for DCIU to be responsible for fully funding a student's preschool needs under the IDA, the student must be found to be in need of specially designed instruction. The record in this case, however, in benefit of any evidence that the student gross and fine motor development delays require that adapting the content or delivery of instruction to address students' unique needs, because there is no evidence of record that the student requires such specially designed instruction, he does not meet the controlling definition of a child with a disability and is therefore ineligible for FAP. The hearing officer does cite, and students argue in the instant appeal, that DCIU's own IEP team conclusively found that the student was in need of specially designed instruction when the team checked a box of the student's IEP form indicating the same. We do not agree that the checking of the box without any further evidence of record supports a finding or conclusion that the student is in need of a specially designed instruction. And I have also attached a case brief to go along with this video. And this is the end of my mock live action video.